Yes, Mr.
My Lords, if I could deal very briefly with Mr Justice Nicklin's reasons for finding that the truth defence doesn't succeed. He's put those in admirably concise terms. I can't improve on them, save to emphasise the fact that Mr Justice Nicklin's made a factual finding that the tweet complained of, the defendant's tweet, misrepresented the good advice tweet. And therefore, this court should only interfere with that finding if that finding was perverse. Moving to the claimant's, Ms Riley's grounds, alternative grounds for upholding the rejection of the truth defence, this is just merely advanced as an alternative, should only really be relevant if Mr Justice Nicklin's decision on truth is in fact found to be perverse. But we say a simple way of analysing this case is simply to look at the meaning of the defendant's tweet and look at what it's meant to be reporting on. If I can take you to the meaning, which you'll find at the judgment, paragraph 25, which is page 6262 of the core bundle. You'll see well-rehearsed words perhaps, but the natural ordinary meaning of the defendant's tweet is Jeremy Corbyn has been attacked when he visited a mosque. Well, that's self-evident. The claimant had publicly stated in a tweet that he deserved to be violently attacked, and by so doing, the claimant has shown herself to be a dangerous and stupid person who risks inciting unlawful violence. People should not engage with her. Now, of course, we must focus on the second meaning, because that's the factual meaning. But we do emphasise you do have to look at these matters in the round, particularly when one considers the tweet complained of was only a few sentences, and any reader would have read all of it. But then if we can turn back to where this whole saga began, which is at paragraph 5 of the judgment, which is hard copy 55 of the bundle, PDF page 79. You see, this starts off with the Owen Jones tweet, which just says, oh, I think an egg was thrown at him, actually. I think sound life advice is, if you don't want eggs thrown at you, don't be a Nazi, seems fair to me. Now, we say that that's a fairly anodyne tweet that doesn't come anywhere near expressing what's said to be the second element of the meaning found by the court. That's the factual meaning that Jeremy Corbyn deserved to be violently attacked. Now, if you turn the page and look at paragraph 7, you'll see the good advice tweet. And all the good advice tweet has done to the Owen Jones tweet is add the words good advice, an emoji of a red rose, same emoji almost as Owen Jones's, and added an egg. And we say that tweet, for reasons which almost don't need to be gone into, is fundamentally different to the way the defendant reported what that tweet said. And actually, a very straightforward way of looking at this, and it's strangely alluded to by Mr McCormack this morning. If a reader had in fact looked at the defendant's tweet and then said, oh, a reasonable reader, I'll go and have a look, see what Rachel Riley said. This is outrageous that she's doing this. Maybe I'll go and add a comment to Rachel Riley's tweet, tell her how bad she is. Now, if that person then looked at Rachel Riley's timeline for that day, which sets out all of Rachel Riley's tweets, they'd be looking in vain. They would skip over the good advice tweet because a reasonable person wouldn't realise that that was in fact what Laura Murray was tweeting about, because the difference between the two tweets is so fundamentally different and unbridgeable. I'll also now turn to the...
You have to add in knowledge of the assault on Mr Corbyn, because otherwise none of it really makes sense.
Yes, that's the context.
But all we're told about that in the judgment is in paragraph 6, which is assault with an egg while visiting the mosque.
Yes.
Hitting Mr Corbyn with an egg.
Yes. And from that, that context and the wording of the good advice tweet, the appellant goes too far in what is clearly a case of misrepresenting what Miss Riley said, and thereby so doing seriously misleading the readers of the defendant's tweet. Well, turning now to the honest opinion defence, if I can deal firstly with the respondent's additional ground, which comes naturally first in time because it concerns the second condition necessary to establish the defence. And the second condition is set out at section 3.3. And it's page 1162 of the Authorities Bundle 2, but it's so short you may not need to go to it, or it's also said an hour ago as an argument. The second condition is the statement complained of indicated, whether in general or specific terms, the basis of the opinion. Now, our submission is a straightforward one, and that is that for a basis to count, it must be a real or a true basis, or in the expression beloved of libel lawyers, it must be substantially true. It doesn't necessarily have to be wholly true. And we say a basis cannot be something which is untrue. A basis cannot be something unless the basis actually exists. Now, element 2 of the meaning sets out the wording of the tweet. It was in fact not published by the respondent, by Rachel Riley.
Was this a submission that was advanced below? Because the submission that's recorded in the judgment at 88 isn't quite the same as what you just submitted as I read it. Because the judge, rightly or wrongly, records you as submitting the basis of the opinion was not properly indicated, can't rely on the GAT as that's only available elsewhere. Reader of the defendant's suite only had defendant's summary of what the claimant alleged to have said. Reliance on understanding of GAC self-serving and impermissible. Opinion itself cannot be based on opinion held by the defendant. So I'm not saying that your present submission is completely different, but it's not. Doesn't seem to me it's quite the same, is it?
No, I haven't checked what was said at the trial because I took it that no point was taken in the skeleton argument put forward by the appellant in response.
No. It's common on appeal for arguments to get refined, and that doesn't mean to say that it's there's the refined argument is impermissible. That wasn't why I was asking the question. It's just that obviously, when a point is raised by way of a respondent's notice, one of the questions that this court is always interested to know is has the judge expressed a view on the argument as now formulated, and if it's been refined, he may not have done.
Well, the view he expresses, he doesn't give any reasons at all. He just says, forgive me, I don't have the paragraph reference.
92.
Paragraph 92.
Yeah. Oh, no, sorry, that's the wrong paragraph. No, it is 92, yes.
Yes.
Because that's what deals with both 3.2 and 3.3.
Yes. But he was... he clearly set out his finding there. He doesn't set out any reasons for that finding. I can't recall precisely how it was put at trial. But obviously I accept what Mr Justice Nicklin recorded there. But I would ask to be able to develop...
But what's wrong? I mean, you're absolutely right. The judge's reasoning on this point is brief. But what's wrong with it? Because the tweet complained of, why does that not indicate the basis of the opinion that's being expressed?
It does.
When it says in the second paragraph, Rachel Riley tweets that Corbyn deserves to be violently attacked because he's Nazi. So why is that not indicating the basis? Albeit, you then get into issues as to whether that basis is factually true and then whether
Yes.
there's an honest opinion and so on.
It's conceded that that is the basis set out in the tweet complained of. But we say it's an illegitimate basis because it doesn't exist in fact. And because it doesn't exist in fact, the second condition cannot be made out.
This would be quite a radical change from the common law, wouldn't it? Right, that the explanatory notes on which you rely say in terms that this subsection is derived from the Supreme Court decision, and quotes the passage in question. And you're saying they actually did, they achieved something completely different and incorporated some other test from another part of the five-part common law test.
Well, this is where really looking at second condition and the third condition together, reading them together.
What you're really looking for is somewhere in subsections 3 and 4 to locate the proposition that the facts that are identified as the basis for the comment have to be true.
Yes, and it's.
I don't think it matters to your
spills over into.
The judge found it in subsection 4.
Yes.
This argument is alternatively you can find it in subsection 3.
Yes. And we say it's difficult.
Or both.
Well, precisely.
Isn't that the problem?
Precisely.
Because if you import somehow into the very simple words of subsection 3 a requirement that some extraneous fact has to be proved, so it doesn't just have to be indicated, it has to be indicated and true, and you've got two concurrent truth conditions, one in subsection 3 and one in subsection 4, which are different.
We would say as a matter of law in Spiller and Joseph, it does establish that the facts upon which the opinion are based need to be true or substantially true. It's difficult when looking at the second and third conditions to see where that stipulation, which we say provides for basic fairness, is best included.
But you seem to be conflating two different questions. One is whether there is a factual basis for the opinion. The other is the question of truth or falsity. Let's take the second part first. I see no difficulty at all in the proposition that subsection 4 clearly refers in paragraph A to facts which are true. Because when you look at paragraph B, it says anything asserted to be a fact in a privileged statement. So that clearly embraces things which are assertions but turn out not to be facts. But a fact which is false is not a fact in A. So insofar as your submission is that reliance upon 4A involves reliance upon something that is a fact,
yes,
that is to say something which is true as opposed to something which is false, that's no problem. But it's a step further, isn't it, to say that in subsection 3 there's some requirement of truth for as being qualifying basis of the opinion.
Yes. It partly would depend on how the judgment is formulated. Clearly, from the respondent's point of view, if you follow through with the judge's interpretation of the third condition, then Miss Riley wins on the appeal anyway. But the second condition we would say is also worth thinking about in case you feel that is the best part of the defence in which to consider whether where a defendant has pointed a reader in one direction, set out a fact, should the defendant, by having set out that fact, be able to say, well, look, there's the basis of my opinion, therefore it is opinion, when actually fact is no such thing, and the opinion is built on sound. Now, that's the general principle. Whether it's achieved in the way that the third condition is construed, or the second condition is construed, it probably doesn't matter much.
I'm just puzzled as to how this can possibly interact with any sensible meaning of subsection 4. Because suppose you get to the point, you inquire under subsection 3, what facts are indicated as the basis for the opinion? Are they true? And you either find that they are true, in which case you've got that condition satisfied. What's the function of subsection 4 then? Or the facts are not true. Subsection 4 suggests that there's still a defence if there's some other fact that's shown to be true.
The difference being that in section 4, it's how things would appear to an honest person, which gives the defendant a very wide ambit. An honest person could reach unreasonable, objectionable conclusions, but that conclusion will still be satisfied under section 4. And really, you can see the common law test that the opinion defence would be satisfied if an honest person could reach the relevant opinion based on a true fact. The problem is the wording on the third condition says effectively any true fact. And perhaps the wording of the second condition achieves that or avoids that mischief and makes sure that the defendant must set out, if the defendant's going to rely on a basis as the true fact, then that basis needs to be true.
The only authority that you've identified that deals with this, you say deals with this,
yes,
is Berkey.
That's correct.
And you say we should read Berkey as pronouncing that subsection 3 is the location for the erstwhile common law requirement that the underlying facts be true.
Yes. Obviously, you're not bound by it.
Well, I'm not sure we'd be bound by it if it was a decision of this court, because I can't see that that's what Judge Parks was saying. So that's my problem with it.
But
on the facts,
I've read it in a different way.
On the facts, it was really simple, wasn't it?
Yes.
I mean, the opinion was completely unfounded, and the point was unnecessary to the decision anyway. But it's a bit of a sort of general disquisition on the implausibility of Parliament having legislated away the requirement for some link between the basis, stated basis of the opinion and the truth.
So would I conclude that your interpretation of it, he's saying that you do need that context?
He's saying it's always been the law, you have to have true facts. You can't defame someone by an opinion based on untrue facts. This section can't have done away with that. And I see that subsection 4A says it's got to be a fact, which must be a true fact. And then he goes on to the facts of the case, and there aren't any. End of story. But he doesn't say anywhere, does he? If there's a passage that you say it expresses the view that subsection 3 imports a requirement that the indicated basis be true, then I'd like to know which it is.
If it's anywhere, it's paragraph 230 of the judgment, which is cited in our skeleton, paragraph 27.
Yeah.
Which paragraph of the skeleton?
It's
230.
230. It's page 711 of Bundle Authorities 2.
No, but where in your skeleton?
Paragraph 27, my lord.
Thank you. So those paragraphs, yeah.
So, as I understand it, it's really reading 229 and 230 together, because in 239, as one concedes from the context of 227 and 228, he's commenting on the term basis in condition 2. And he says basis might be factual, some might be something broader, And he then goes on to say, if the basis is factual, then the factual basis must be true.
Yes.
But
And
he's
clearly
not saying because of 3.3, because he then goes on in the next paragraph to talk of 3.4a. And I mean, if you're looking at 3.4a, it says any fact which existed at the time. Well, a fact to exist has to be a true fact.
Yes.
So how do you get it from 3? And indeed, if you had 3 read in the restrictive way that you intended, you would end up undermining what Judge Park says was permissible, namely to comment on a political policy.
Oh no, because the word basis is flexible. If the basis are factual, you've got to prove the facts are true. If the commentator is just saying, I went to see a new play in the West End last night, it was an absolute load of rubbish, you don't have to set out true facts to prove it's rubbish. You just have to say, well, look, this is what I'm commenting about. It's the honest opinion defence is a strange one. It covers comments on facts and comments of public controversy. So the use of the word basis is quite a useful catch-all phrase for covering, for instance.
But I don't think that can be right, can it? Because the way it's been replicated in the, replicated isn't the wrong word. The way it's been dealt with in section 3 is that you don't get home unless you prove that an honest person could have held the opinion based on some fact.
Yes.
So in your example, if you just said, well, there's a play, that's really not a fact that could possibly support the honest opinion, because you'd have to say something more about the play to support the opinion.
Well,
that would be a fact about the play. And section 3 doesn't allow a defence of honest opinion which is not based on some fact.
Well, the fact would probably just be the existence of the play.
The existence of a play and a performance
Yes.
to which different people will react.
But that's the Royal Aquarium case. It's you have to have some sort of look. It doesn't
I think
the limits are very broad.
It's
And people can be prejudiced, obstinate, but if something just didn't happen in the play,
yes,
which justified or supported in any way the comment that it was obscene, I'm thinking of Royal Aquarium in Parkinson, then that's not an honest opinion, because it's just based on a completely unfounded view account of the play. So
it depends on the comment. If you just say it's rubbish, then clearly that's defamatory. You're talking about a play, people can identify it as comment and just say, well, that's the theatre critic's review. But the context would be very different if the reviewer said, this play is obscene. You need something more than that, because you couldn't reach the conclusion it was obscene unless something had happened in it which justified that.
Yeah. Anyway, we're sorry, we're leading
It's,
quite a long way away from subsection 3.
Well,
but then with the submission is that read in its context, paragraph 230 of Judge Parkes' judgment means that subsection 3 incorporates a requirement of truth.
Yes. And we say there's a substantial truth of any fact referred to, of the basis. And we say that's a perfectly commonsensical way of interpreting the statute. And I do rely, I realise it's only one case, and you've pointed some criticism of it, or criticism of my interpretation of it. But I would say the fundamental point His Honour Judge Parkes is making is, again, it comes down really to the same point, which is considered under condition 3. If you point a reader in one direction, if you're pretty much holding the reader over the page, saying, look, this is the fact I rely on. Rachel Riley's tweeted that Jeremy Corbyn deserves to be attacked, then that basis needs to be substantially true for the honest opinion defence to survive. And that's a matter of pure justice and common sense, and stops readers being deceived. The writer, the defendant, can't write something as the basis for the opinion, the very foundation for the opinion, and then when it comes to defending a case in court, point to something completely different, which is substantially true. It's what the reader's been pointed into the direction of that needs to be substantially true. I'd say well, the submission I'm making, in fact, has always been the common law.
Well, yes,
I think that's Joseph and Spiller thinking back to it. That's one of the points that Lord Phillips makes, providing, he says, words to the effect, I'll ask Mr Basuto to check this, providing, of course, that the facts, I don't know if he uses the basis for the opinion, have been truly set out in the words complained of.
Well, in Joseph and Spiller, the court approved with modifications what had been said in Che and Cheng, and that's all set out in paragraph 3 of the Supreme Court judgment. And the fourth condition, the third condition is the comment must be based on facts which are true or protected by privilege. The fourth and separate condition is that the comment must explicitly or implicitly indicate, at least in general terms, what are the facts. So they're two separate conditions, linked at common law, but two separate conditions. And the explanatory notes tell us that section 3, subsection 3 was based on the second, what was the second of those conditions. Actually quote those words. So it's a little difficult to see the force of this argument if one is allowed to look at the explanatory notes to work out what they were trying to achieve. Because they seem to say, in terms, this is the condition.
I would say it's dangerous to link the explanatory notes with too much precision to particular paragraphs of the statute. I think the underpinning matter one can take from the explanatory notes, which is really an expression of Parliament's intention, is that the honest opinion defence was not to be a departure from the common law, but was to codify it in a simplified way. He says, suppressing a laugh, frankly, because clearly, as demonstrated, degree of discussion taking place today hasn't been achieved.
Yeah.
But if one looks at it bringing into statute the broad principles of the common law, then we say it's right that if you set out a basis, which in this case is a fact, then that basis has got to be true, because that's the springboard, that's the foundation stone of the opinion. If you take away that foundation stone, the opinion, the honest opinion defence must fall.
Yeah.
If I can now move on to the appellant's case regarding Mr Justice Nicklin's judgment on the third condition. Again, I really think it's being lazy, but there's no point in repeating what Mr Justice Nicklin sets out in his judgment, which we rely on. And I also emphasise the fact that, of course, one looks at the explanatory notes and other material to try and resolve an ambiguity, but also in order to try and stop a statute amounting to or having the consequence of causing an absurdity. And we say the interpretation contended for by the appellant would result in the absurd position where the defendant, having quite deliberately and in black and white language set out the fact she relies on, to then turn around and say, well, actually that's not the fact I rely on, I'm going to rely on something different, and I can rely on a different fact anywhere. to establish that an honest person, which is a very wide test, could have reached the opinion that I actually reached. And again, we say really the same reasons of principle as outlined in considering the second condition. That would be an absurdity, and it would not foster freedom of speech or the public interest in freedom of speech, because it would mean that the readers of the tweet were being misinformed.
What about the proposition that the word any fact, which existed at the time, is deliberately wide and is really meant to mirror the truth defence, which enables you to get lucky by finding a fact which you didn't know about, which shows what you said was true?
Well, the truth defence has always given a wide latitude, because you can rely on any fact, regardless if the defendant knew those facts or not at the time of publication.
Well, you could at common law. Parliament thought that was a good rule and incorporated it into the statutory defence. What's wrong with the proposition that Parliament might have thought that was also a good law to incorporate into the honest opinion defence?
Well, there's nothing to indicate that's the basis of Parliament's reasoning. And we would say you've got to look at the two defences. They're trying to achieve different things. Truth is an absolute. A defendant could have published a serious allegation with no belief in the truth, but ultimately have a defence because what's true is true and the public is properly informed by the dissemination of true information. In an honest opinion defence, what you're trying to do is give someone a latitude to make a comment or offer an opinion on existing facts. Now, the key point, I think, is there's always got to be a nexus between the opinion and the fact, because one informs the other. And in this case, it's quite obvious because the meaning, the third element of the meaning, begins with the words "by so doing," is tied back to the fact. But really, in all honest opinion defences, the opinion will be about a fact or a subject matter, for instance, a play, something of that sort. Therefore, you've got to have the nexus between the two. And it's the right of the defendant, who is the commentator, that's being protected. And it's not unreasonable to say to the commentator, well, you've got to be commenting on the fact you've told the reader you're commenting on. It's the wording of Section 4 is clearly not satisfactory to a degree, but one must look to the purpose that Parliament was trying to achieve. It wasn't trying to achieve an absurdity, it was trying to enact the common law in an easily understandable form. And the interpretation of Section 4 advanced by the appellant would do anything but that. It would do the opposite.
So you just said it was trying to enact common law. Do you take issue then with the proposition that Section 3 was intended to broaden the defence?
I think that was achieved in the Joseph and Spiller case, Supreme Court case that was heard a few years before the Defamation Act. Explanatory notes say that Section 3 is in effect codifying Joseph and Spiller. There's nothing to suggest that Parliament wanted to go any further than the Supreme Court went in Joseph and Spiller.
Well, there is, because they got rid of the requirement of public interest.
Oh, well, I think in Joseph and Spiller, Lord Phillips says in very strong terms that should no longer apply.
Yes, but that wasn't the law as they declared it. The law was then, as it always had been, that the defence was only available for a comment on a matter of public interest, and that was abolished and not replaced.
Yes, but it was abolished. Really, if you follow it back, following the, if I can call it, the strong recommendation of the Supreme Court in Joseph and Spiller, it was a baton taken from Lord Phillips. It wasn't something that Parliament itself decided upon. I mean, maybe, without wanting to turn this conversation to be too academic, my Lord Justice Warby be familiar with the case of Kemsley and Foote, which is where a newspaper proprietor, Kemsley, was libelled by the description of someone else as being lower than Kemsley. And a fair comment at defence, that, as it was called at that time, was advanced. And the court, the House of Lords, concluded that, that in that case, the defendant could rely on any fact. And really that was designed to deal with the situation where the fact is obviously outside the words complained of, because it was a general reference to the way, perhaps he's the Rupert Murdoch of his era, Mr Kemsley was running his newspapers. Now that doesn't particularly help in your task of statutory interpretation, but it may be why the word any fact was included there in section 4 to cater for that situation, where the fact, you do really have a scenario, which won't be very often, when the fact is actually outside the words complained of, and you're trying to refer to a play or the way a newspaper is run or something of that sort.
Well, I think that the House of Lords held that this was a case about sufficient indication, wasn't it, Kemsley and Foote?
Yes.
And because everyone knew who Kemsley was
Yes.
and what he did, that he was running a newspaper empire, it was the use of his name was enough.
Yes. So the defendant in the Kemsley case would be able to rely on the words there any fact. But whereas here, and in most cases, where the defendant has pointed the reader to a particular fact in the words complained of, we say that the defendant cannot then pivot and look for facts elsewhere when faced with the unfortunate circumstance that the fact that the reader has been pointed in the direction of is in fact not substantially true. What else? Could I turn now to the public interest defence? The first ground is that the first ground advanced, alternative ground advanced by the respondent, is that publication was not on a matter of public interest. Now that is an argument which was run at the trial. And it was run on the basis that there was nothing in the good advice tweet which constituted a matter of public interest. And we say that that is fairly obvious. But before I move on to that, perhaps I could take you...
Can you just tell me, I mean, that submission seems to part company with reality in circumstances where there was a background of violence against politicians, public concern about violence against politicians, and an actual attack that very day on Jeremy Corbyn, albeit only in the form of egg throwing, but nevertheless an attack.
They are all matters of public interest. We wouldn't disagree with that for one moment.
Right.
But that doesn't mean that all comments and tweets about those incidents are also of themselves matters of public interest. Now, in our Skeleton argument, we rely on the Court of Appeal case of Seraphim, which sets out examples of matters which are of public interest. I'm not going to go through them because we've said they're self-evidently obvious matters real matters that concern the public, the running of the government, the running of the civil service, the conduct of MPs, and so on and so forth. But when you drill down to it, what one must do, it's not enough just to turn up to court and say, oh, well, Rachel Riley tweeted this material on the day Jeremy Corbyn was attacked, therefore this concerns a matter of public interest.
No, obviously, it doesn't mean you can rely upon the background political situation as justifying any published statement. Of course not. But this was not just any old published statement. It was, first of all, a comment in some shape or form on Owen Jones's tweet. Secondly, Rachel Riley herself, linked it to ongoing debates, particularly through the use of the red rose symbol.
Yes. Yes, but if there is a public interest here, it's not the one identified by the defendant. It's Rachel Riley saying, well, look, you can't have it both ways.
Well, that's rather assuming
It
the
depends.
meaning of the GAT in your favour, where the
Yes.
judge has said it's ambiguous.
Yes, and of course I'm tied to that. But if you just look at the tweet itself, we would say it's just a humorous comment ribbing Owen Jones.
Why isn't that a matter of public interest when you were saying either a journalist has been hypocritical on your meaning, or you're actually espousing an attack on their meaning? I mean, those are all matters of public interest. Are they not?
We put forward an interpretation of the good advice tweet, which is set out in our respondent's grounding in regard to the truth defence.
Well,
which,
to be sure, but that's
Yes.
partly why I'm asking the question. I understand your case on the meaning of the good advice tweet, but if you, and that's your first point on the respondent's notice, if you got home on that, this question would never arise, would it?
yes, that's correct. That's correct. Can I just start at the beginning and just turn to the judge's reasons why it's in the public interest, or on a matter of public interest,
Yeah.
which we say are palpably wrong. And you'll find that page, paragraph 120 of the judgment. Paragraph 120 of the judgment, page 90 of the print copy, page 114 of the PDF copy. If I can just go through it sentence by sentence. First sentence is irrelevant. The claimant's good advice tweet was published on Twitter on a public platform. It was intended by the claimant to be read by a large number of followers, or more widely. We say, well, that's got nothing to do with the matter of public interest, as understood for the purposes of the Section 4 defence. Then he says the claimant was well aware of what words in the good advice tweet were likely to provoke public comment and engagement. And we say that that's not relevant. What matters is the subject matter of the good advice tweet.
So if she'd gone on local radio and said, got something to say about what Rachel Riley has put on Twitter to whatever the number is, hundreds of thousands of people, would that have been a matter of public interest? This is a public platform.
Well, no, it's got to be, subject matter has got to be a matter of public interest. You could equally say, because something's said on a public platform, that something said about a contestant of Love Island, or Celebrity Big Brother, or someone's behaviour outside
No,
of
I didn't express myself very well. What a public figure says to hundreds of thousands of people, whether it be that a journalist has been hypocritical, or that Jeremy Corbyn deserved to be egged, or something more serious, is that not a matter of public interest?
Not by reason of the person's public profile. Certainly not someone at the level of Rachel Riley. You might say that in regard to a senior politician. It's someone who's simply well known cannot be the subject of libels which could be protected by a public interest defence, when they could be criticised for elements of their personal life.
In the
It's
overall
got
fair comment, you could, if you put out something for public consumption, a literary work of any kind, be it an article in a newspaper or a play or a book, that work was a matter on which it was permissible for people to comment as a matter of public interest, because you had placed it before the public, and they were therefore entitled to comment on it as a matter of public interest. Is the Section 4 defence narrower?
It's not the same, and it doesn't encompass.
In your view, it must be narrower, because if the book was about the love affairs of 18th century Englishmen in London, that wouldn't be a matter of public interest of the lofty kind that you've just been referring to. But it would have been a matter of public interest for the purposes of the fair comment defence, but not, you would say, for the purposes of
the fair comment
Section 4 defence.
defence is a different creature. I mean, what the fair comment defence is saying and evolving in its definition of the public interest. It's saying that you need a public interest in order for the fair comment defence to succeed. And in order to ensure that the comment could be made about plays, books, newspaper articles, and so on, there's a very wide definition. And that's reasonable because by its very nature, what is being offered is an opinion about the play, the book, and so on. But when you're considering a public interest defence, it could be about an opinion. But
Yeah,
on the whole,
but let's come back to what the judge actually says. I quite understand your point, but the second sentence about it being a public platform, large number of followers, is not enough on its own. But that's not what the judge is saying. That's the context for what he says in the following sentence. So let's take a silly example. Suppose your client had tweeted, "Today I've been relaxing with a gin and tonic." So the fact it's a public platform, the fact that she has hundreds of thousands of followers does not make that a matter of public interest. But that I could understand as a submission. But what the judge then goes on to say was the claimant was well aware that her words in the good advice tweet were likely to provoke public comment and engagement. And then he says, comment on response to the good advice tweet was a matter of public interest, not a personal or private matter. So it's not like my gin and tonic example. On the contrary, this was political debate. I appreciate he doesn't say this was political debate, but that's the thrust of the reasoning, isn't it?
Well, he just says it's likely to provoke public comment and engagement. There has to be something more that unlocks the public interest door. It's got to be something, the subject matter of the good advice tweet has got to concern a real matter of public interest. The public interest door cannot be unlocked just because someone who's relatively famous and has lots of followers on Twitter has tweeted something. Public interest defence.
Has tweeted something about a politician being attacked.
Well, yes.
Yes. Well, isn't that a key that unlocks the door you want us to unlock?
My Lord, there's not much more I can say, just in conclusion, that by dint of the appellant's role as a public person, that doesn't open her up to public interest of this sort. Yeah. And on analysis, the good advice tweet, certainly if you accept the rationale, the interpretation given to it in the respondent's notice, is not a matter of public interest between which there's a nexus between that public interest and what the appellant actually wrote. There may have been a public interest in opening up a debate. Is it a good thing to say, oh, it's all right to egg Nick Griffin, but not Jeremy Corbyn? That's perfectly reasonable analysis of that, but the public interest being relied upon by the defendant is quite different because there needs to be a nexus between her public interest and what she stated, and the nexus really comes out of she needs to establish that Rachel Riley was tweeting that Jeremy Corbyn deserved to be violently attacked. My Lord, moving on to the appellant's ground, which challenges the judge's findings about was it reasonable to conclude publication was in the public interest. Again, there's little I can say that improves upon Mr Justice Nicklin's analysis. But I would emphasise that in this case there was only one fact which really mattered for analysis by the defendant, and that was the contents of the good advice tweet. And really, whether one goes down the ambiguity route or the route advanced in the alternative ground under the truth defence. Either way, it comes back to the point that there's an unbridgeable gulf between the tweet complained of and what Miss Riley actually stated in the good advice tweet.
Well,
And it's
yeah.
and it's
Yeah,
simply not.
or specifically, as you pointed out earlier, an unbridgeable gulf between the single meaning of the defendant's tweet as found previously and what's in the good advice tweet.
Yes, yes. I mean, you can look outside the single meaning, but the single meaning in this case is so close to the original tweet, there's not much in it.
Yeah.
And again,
But what do you say? I appreciate you got your respondent's notice on the public interest point. Assume, for the sake of my question, that we're against you on the respondent's notice. What do you say about the point that Mr McCormick made towards the end of his submissions, which is to say that the judge's analysis was too limited because he hadn't taken into account in his assessment of reasonableness all the other factors that were relied upon by the defendant?
can I just go to the defence?
So in other words, just to complete the question, to give you the full context, this is Mr McCormick's trump card submission. So he says the judge was in error because he treated misrepresentation as a trump card when he should have considered a broader range of factors. That's the argument.
We say there was only one factor. It's the good advice tweet. That's the source the stated source material in the defendant's tweet.
And just to sort of tease that out a little bit, am I right in understanding that what you're saying then is that the broader range of factors might well bear upon the question of public interest, but they don't bear upon reasonableness of the belief on the facts of this case, because in this case it's only about the interpretation of the good advice tweet?
Yes, and the defendant, if I put it this way, took an editorial decision just to talk about the good advice tweet, nothing else. And it's worth emphasising, if it needs to be emphasised, that there is a finding that the defendant misrepresented the good advice tweet. Misrepresentation cannot be reconciled with reasonable behaviour. Especially, as the judge makes clear towards the end of his judgment, given that the allegation being made against Miss Miss Riley was such a serious one, effectively one of inciting violence. My Lords, if I just conclude with a miscellaneous minor point. It may be of interest, in the Supreme Court in the case of Seraphim, Lord Wilson did use the explanatory notes to the Act in analysing what Section 4 of the 2013 Act meant. And you'll see those references at paragraph 58 and 66 of the Supreme Court judgment.
Sorry, 56 and
Oh, pardon me, 58 and 66.
58 and 66. Thank you.
My lords, unless I can be of any further assistance.
No, thank you, Mr. Bennett. Mr. Corbyn, any reply?
My lord, yes. The first point made by Mr Bennett shortly before the luncheon adjournment was to try to draw a distinction between the concept of a violent attack and what actually happened to Mr Corbyn and Mr Griffin. The act of throwing something at another person is a violent act. I accept it's nowhere near the top of the scale, but it is a violent act. In judgment paragraph 74, the judge referred to the good advice tweet. It's at the top of C80, PDF 104. Alternatively, this is one of the two obvious meanings. The good advice tweet could be and was read in a similar way to the defendant's interpretation. That Jeremy Corbyn was a Nazi and he too deserved to be similarly attacked. Similarly, does refer back to the throwing of eggs at politicians. But the judge wasn't drawing any real distinction between my client's meaning, as set out in paragraph 25, factual meaning, and the throwing of eggs at politicians. It's a violent act. It was my client's evidence in her witness statement. For the reference, it's paragraph 32, supplemental, page 34, that the person who did this sentenced to 28 days in prison on the basis that this was a violent act against the politician and it needed to be marked with a custodial sentence. So the implicit, perhaps, submission that this isn't really violence, it's not something that meets the sting of the libel, is not one that this court should contemplate. On the first ground of appeal, Mr Bennett simply recites the failed case at trial, which was that the defendant's meaning wasn't a reasonable meaning. But what he's unable to do is to take your lordships to the relevant paragraphs of the judgment and explain how he can make that submission to you. Paragraph 74, the judge refers to there being two obvious interpretations of the good advice tweet. I accept that the judge does not make explicit a finding that each of those is a reasonable meaning. But it defies sensible argument. But for the judge to have decided that each of these is an obvious meaning, that either or both is not a reasonable meaning. There's no basis for distinguishing between his treatment of the two meanings. So if the defendant's meaning isn't a reasonable meaning, there's no reason to assume the hypocrisy meaning is a reasonable meaning, and we're then left with a statement for which there is no meaning found. The judge was clearly here making a finding that both meanings were reasonable, and we're using the shorthand of Ajinomoto for malicious falsehood claims, a range of reasonable meanings. There may be others that would fall within that range if people chose to look for them. But each of these two, in my submission, clearly fell within that. And if the judge had intended to exclude either, and particularly the defendant's meaning, from that reasonable range, he would certainly have said so, because it would have been fundamental to whether or not only the truth defence, but more importantly, the honest opinion defence and the public interest defence could stand at all. Because if it was an unreasonable meaning, neither of those defences would trouble the judge. In my submission, there's a simple failure to reflect the reality of this judgment.
Well, I see the force of the point you're making, but just can I be clear how far you're taking it? Because as I read this passage in the judge's judgment at the moment, I'll obviously have to reread it after court. What the judge is doing here, with regard to the meaning of the good advice tweet, is his fundamental finding is that it is ambiguous. He says that at 74, and he comes back to that perhaps with even more force in 76. He says it's not appropriate to oppose an artificial single meaning on the good advice tweet. To do so would stifle the very important fact that it was ambiguous. Now, I appreciate your submission. That has consequences for the respondent's notice argument. But why does it not, by the very same token, have consequences for the appeal?
Well, my Lord, because what the judge is doing is saying, I'm not going to apply the single meaning rule because it's inappropriate to strive for that artificial outcome, and it's unnecessary. What he doesn't say is that because it's ambiguous, people would not have taken one or other of those meanings. And we've had the enlightening discussion about the true meaning of ambiguity. But in my submission, the reality is, in ordinary life, that if there is an ambiguous statement made, most people will take one or other of the meanings, and some people may spot that there are two meanings and recognise the true ambiguity. The utility, or sometimes the vice of ambiguity, is that you can say different things to different people.
But I appreciate that people may take one or other meaning, but the court's finding here is it's ambiguous.
But, my Lord,
And it follows that it doesn't bear the meaning contended for by the claimant, and also it doesn't follow that it bears the meaning contended for you by you.
Well,
it is ambiguous. That's the finding.
well, my Lord, that's why we get to the argument over what ambiguity actually means. Your Lordship, I anticipate, is saying if it's ambiguous, it doesn't actually mean either A or B. It can only mean both A and B, and therefore anyone who doesn't spot both A and B isn't actually the reasonable person.
No, it is a statement whose meaning is uncertain. It's ambiguous.
But if one is looking at the way in which that statement actually impacts upon readers, which is what my client was tweeting about, one has to look at how that meaning is being perceived.
Well, she was tweeting according to the factual allegation as defined by the judge about what had been stated, not
Yes.
about what people had taken from it.
Well,
She
and
wasn't saying people have understood her tweet to mean these things. She was saying she had stated them.
and she is doing that based on having read the tweet and having seen the reactions to it. And your Lordship
Or
has...
some of them.
Sorry?
Or some of them.
Well, the reactions that she had seen. And your Lordship, we again, at the end of my submissions, your Lordship directed me finally, I think, paragraph 126, where we had the implicit recognition by the judge. Yes, it's 126 on C91 or PDF 115. That my client's witness statement was that she'd only seen people taking her meaning. She was cross-examined and reaffirmed that evidence. It's not put to her that that's not right.
No, I'm not going back over that, and I'm not inviting you to go back over that territory again.
No.
We've covered it.
But that's what she is doing. She's thinking that's what this tweet. This is a statement.
I think the question my Lord has raised is a challenge to your submission earlier. That the judge had found that the GAT meant that bore the meaning that your client contended for.
As well as
the answer, the proposition is, whatever ambiguity might mean in other contexts, the judge has told us what he means by it. It's a statement that is open to more than one interpretation, and he's identified the ones that he is talking about. So that's the difficulty, as I see it, for this argument, because the judge has not found that it meant those things. He said it's open to interpretation. It could be read as meaning one or the other.
well, Lord, in the context of what the judge was trying to do, which was measure substantial truth of my client's tweet and the allegation within it against what the good advice tweet said, which was his purpose, for the judge to set out the two obvious meanings that he did, but for this court to infer that the judge has not found that both of those are reasonable meanings for people to take, because there are statements to that effect made, would my submission be wrong?
Yes, but it might well, but that's not what I'm suggesting.
My apologies.
What I'm struggling to do is to identify the distinction between the judge finding that the words meant those things and the judge finding that the words could be understood to bear either of them. And I'm suggesting that those are two different things. And if the judge had said, it meant this, and it meant that, then your submission would have greater force than at the moment it seems to me to have.
Well, in which case I think we're coming back to the question, the debate we've had at least twice now about the true meaning of ambiguity. And we take that as meaning there are words which bear more than one meaning. They make more than one statement. And that means that there are two statements contained within the good advice tweet. One, the hypocrisy statement, the other, the deserves to be attacked statement. And if what the judge was doing was adopting the approach that my lord has just suggested, what the judge has effectively decided is the good advice tweet doesn't actually have any meaning. It doesn't make any statement because it's ambiguous. And that clearly can't be right.
No, it does make a statement. It does have a meaning. It's an ambiguous meaning, open to more than one interpretation.
Well, my lord, to some extent, well, many statements will be open to more than one interpretation. And it's the inherent imprecision in language and understanding, which is why the single meaning rule is artificial and it's imposed for a reason. But were it not for the single meaning rule, we would always accept that every statement is open to interpretation and a variety of meanings can be taken, and we would use the reasonable range of meanings borrowed from malicious falsehood and certain other areas of the law. If a statement is ambiguous, I take that to mean something that is over and above usually imprecise and capable of different interpretations from readers. But it's still only giving different meanings to different readers from the same words. It's conceptually no different to a statement that would be the subject of a malicious falsehood action.
But as you pointed out this morning, with considerable force, if I may say so, what's different here is that you've got a statement consisting of two words, good advice, which, while it has a literal meaning, is close to being meaningless. It's not actually meaningless because we all understand what good advice, but it's all about implication.
Yes, but
derived from the context. And what the judge is saying in this particular case is that the statement actually, in context, was truly ambiguous because you could read into it completely different things,
yes, but
and therefore arrive at really quite radically different interpretation.
yes, but the ascertainment of meaning always allows for the possibility of implication, whether it's done on James or Kutsuyagamis principles or on Ajinomoto principles, reasonable range of meanings. The implication of meaning, because there are large gaps between the lines or between the emojis, is well recognized. It's the same process. It's simply applied with a different degree of rigor if you're looking for a single meaning compared to whether you're looking for a reasonable range of meanings. It's obviously necessary to read into the good advice tweet. And everybody agrees that. And the judge found that the claimant herself recognised that this was going to happen. She recognised that that was going to happen. So the reading into it simply reflects the way in which this tweet, the good advice tweet, was going to be perceived by people. They would need to read into it. And some would read in meaning A, some would read in meaning B. Whether or not one calls that a truly ambiguous tweet, as the judge did, and whether or not that's different from saying this is a tweet which par excellence produces a reasonable range of meanings, there is no real difference, certainly no proper difference, for the disposal of this appeal. My client, who took one of those meanings and ran with it, has tweeted what she tweeted, and it reflects a statement within the good advice tweet. So the suggestion that it's not a reasonable meaning, and I think also the suggestion that your lordship should decide that any finding the judge made that the defendant's meaning was a reasonable meaning should be overturned. In my submission, there's absolutely nothing in there in the circumstances, and there's been no proper analysis given to you of that, rather than simply saying, look at the good advice tweet, it clearly doesn't mean that, without any proper recognition of the context. In relation to the respondent's notice point, can I ask your lordships to just pick up the supplemental skeleton, which is in supplemental bundle 55. And yes, paragraph 4, which is on S56, we make the point that in the skeleton argument filed for this appeal by the respondent, she actually advances the meaning of the good advice tweet, which looks almost indistinguishable from the meaning that my client took from it. Namely, what sauce for the goose is sauce for the gander. Basically saying, if it's all right to throw eggs at Nick Griffin, it's okay to throw eggs at Jeremy Corbyn. Now, we were surprised to see that committed to writing on behalf of the claimant, but on the assumption that it properly represents the position she adopts, we say it simply goes to show that the meaning my client took is eminently reasonable in the circumstances. I'm not going to address your lordships on section 3.3 on the honest opinion point, but in relation to section 3.4, I think by the close of the submissions on section 3, Mr Bennett had accepted that it was wrong to suggest that section 3 codified the common law. It clearly didn't. Lord Phillips' parting shot in Joseph and Spiller was, there is a case for reform. And the 2013 Act was a reforming act for the honest opinion defence. In so far as section 3.4 is concerned, nor can that, as a part of the honest opinion defence, be seriously suggested to reflect the common law. It's universally accepted amongst commentators that you can rely on facts which were not known to you at the time. That in itself is a change in relation to the facts that can be relied upon. No proper rationale has been suggested for not giving the words any fact its proper meaning. And what Mr Bennett did say was that if you point to a fact when making an opinion, you cannot then pivot to other facts if the fact you referred to is shown to be false. But if one looks at the statute, there's absolutely no bar on doing that. Now, that seems to be a product of the old common law approach, and by old I mean before Spiller and Joseph, which is because you refer to a fact and your reader uses that fact to form some sort of value judgment of the worth of the opinion, if you've misstated that fact, you've misled your reader. But of course, Lord Phillips and Spiller set out that the real reason you have to indicate the basis of the facts, of the opinion rather, is to let the reader know what the opinion's about in general terms. It's got no input into whether or not the reader can form his or her own independent assessment of the worth of the opinion. And there's absolutely nothing in the statutory language that says that if you refer to a single fact, but that turns out to be false, you can't rely on another fact which you weren't aware of at the time. Now, of course, one then does get into questions such as, well, how related does that fact have to be to the opinion that you expressed? In my submission, there is no need for any nexus, because the safety valve here is the honesty of the opinion you expressed and the need to be able to show that there were facts upon which an honest person could hold that opinion.
It is a bit curious, because you could hold, indeed the facts in this case are a good example, you honestly believe that the facts were as you stated them to be, but they weren't. So you don't have that fact to support your opinion, but you can find some other fact.
Yes.
It doesn't have to be related in any way. It's had to be tied to the opinion, and it's bounded by the requirements of objective honesty. But it's perfectly possible to have an honestly expressed opinion based upon an honestly held belief in the truth of a fact that was in fact not a fact.
Yes, but
and then it very much depends on the way in which you express your opinion. The range of defence available to you is really bounded by the way you express your opinion. The more general it is, the greater the range of available, unknown, or other facts
yes,
that you can resort to.
yes. If your ability to rely on facts under section 3.4a is limited in any way by the fact you actually state as the basis for your opinion.
Yes. Well, one way in which it might be, and you alluded to this earlier, is if you say, or if the meaning of what you say is, the claimant did X, and for that reason, or by so doing, is a disgrace. And that is more or less, that's the sort of category of meaning that we're confronted with here. And that's where you might get into a problem on the facts of this case. As you rightly pointed out earlier, it puts a premium on the words by so doing.
Yes.
But that would just be a narrow, you might, as it were, lose this appeal on that point by virtue of those words without losing the more general point, without us even needing to address the more general point about the breadth of section 3, subsection 4.
Well, your Lordship's obviously right on that. It may be that I win the argument, but it does my client no good.
On that point.
On that point, of course. But what we say is that we do have facts that we have relied on, even if the connecting words limit us to the good advice tweet. We have got facts within that statement. We have the good advice tweet. It's only if the connecting words require us to prove each and every part of the factual part of the meaning. We've got the attack on Jeremy Corbyn at the mosque, which is paragraph 1 of the meaning. We've got the good advice tweet. What we may not have, and ex hypothesize on this we won't have, is a finding from your Lordships that the good advice tweet bore or made a statement to the effect that we said. But we'll still have the fact that there was the good advice tweet, that it was a reaction to Jeremy Corbyn being attacked at the mosque. And we say that there are other facts that are indicated by that, namely the reaction to it, because that's the dangerous and stupid issue. So we say that even if we're restricted tightly, as we shouldn't be, we have sufficient to set aside 3.4a. Because I don't think there can be any, well, in my submission there can't be any sensible doubt that on that basis, to say that it was dangerous and stupid to put out the good advice tweet to your 675,000 followers in that way would be dangerous and stupid. It's something that an honest person could hold as an opinion, and as the judge found, my client did hold that opinion. If I then move on to the third ground of the respondent's notice, this is whether or not the good advice tweet was a matter of public interest. I'll just give your lordships the note. It's in our supplemental skeleton S57 to S59. I'm not sure whether or not how much this is still pursued, but as we've indicated in paragraphs 10 through to 20, we say it's entirely hopeless and it wasn't the way in which the case was run before. We've set out the passages in the claimant's witness statement and in her evidence in which she actually relies upon her status not as a private individual but as a campaigner. I think in her own words in cross-examination, an extremely prominent person talking about anti-Semitism. Those are matters of public...
specifically within the Labour Party?
Yes. Yeah. It's par excellence a case where she made this statement on a matter of public interest. The way in which she did it, the time at which she did it, and the reactions to it were clearly a matter of public interest. That's the way it was pleaded. In Mr Bennett's submissions on the third round of appeal, he made it clear that there's only one factor really, and that was what he called the unbridgeable gulf between my client, the single meaning of my client's tweet, and the good advice tweet. There simply isn't an unbridgeable gulf. The judge decided that it was an obvious meaning. The judge decided that his client recognised, or must have recognised, that reactions to that meaning would come in, and that the claimant could hardly complain when they did. To suggest that that is finding a fact that allows a submission to this court that there's an unbridgeable gulf, in my submission, it's misconceived. There's simply a failure to recognise the reality here.
Can I just ask you something which I just wonder for your help on paragraph 74 and the obvious meaning? What the judge says is obvious is that it was open to more than one interpretation and was therefore ambiguous. And then he gives two of those.
Yes.
But he doesn't say that either of those were obvious meanings.
Well, he doesn't, but he must be meaning that those are both obvious meanings, because otherwise it would be, the judgment must flow logically and sensibly from one sentence to the next, unless there was some compelling reason to think otherwise. It would be bizarre if the judge was troubling to set out two possible readings of the good advice tweet and was thinking to himself, yeah, but that no reasonable person could have taken that one. Because why wouldn't, as I said earlier, why wouldn't he say so?
Well, perhaps your better answer is paragraph 155, where the judge says, as explained in more detail above, there were two obvious meanings. The hypocrisy meaning, or the meaning that suggested that Jeremy Corbyn deserved to be egged because of his political views. So there, he spells it out.
Yeah, that's why in the skeleton argument this morning, you've got to look at those three paragraphs, 74, 155, 157, where the judge, in combination, the clear message is these are both reasonable meanings.
But worse than that for your client, because they were obvious. And once they become obvious, she has greater trouble explaining why it's reasonable to ignore them, the ones you didn't mention.
Well, what the judge doesn't say anywhere is that they should have been obvious to my client.
Well, that surely is obvious.
Well, I see your lordship chuckle as you say that to me. So I'll take it in that way. The short point there is, well, we have been through this. If it's ambiguous, it may be obviously ambiguous to the judge with the benefit of argument. But
sorry to interrupt you. I don't understand the relevance to your client's subjective belief on the public interest defence, where what she has failed on is an objective requirement of reasonableness.
No, my lord, your lordship misunderstands me, and my apologies. This doesn't go to my client's subjective belief in the public interest of what she tweeted.
Or indeed her subjective belief in the meaning of the GAT.
Well, no, it's whether or not her belief that it was in the public interest to tweet what she tweeted was in the public interest. And if the meaning, Lord Justice Warby is postulating, I believe, that if it was obvious that it was ambiguous, the reasonableness of my client's belief may suffer because it would have been unreasonable for her to believe that she should do what she did without reflecting the obvious other meaning that the trial judge referred to.
Which is how the judge dealt with it, yeah.
So
That was the way the judge approached it. Yeah.
Well, the judge deals with it in terms of she misrepresented. He never says that she actually appreciated that meaning, and therefore it was unreasonable for her to do what she did. The furthest we get is an inference that if the judge says it was obvious, both meanings were obvious, therefore she should have recognised it. But nowhere is there a finding which would have been contrary to her evidence that she did in fact recognise it. And the judge effectively gave my client, and to be fair, Miss Riley, a clean bill of health in terms of honesty in the evidence that was given before him.
Yes, well, you're quite correct in characterising the point that I was seeking to put to you. That was correct. But I don't think it's an answer to say, which I think is probably, well, as we've debated at great length, that there was no finding that she subjectively realised that that was the meaning of the words. Because we're talking here about the reasonableness, the objective reasonableness of what she did, or rather the objective reasonableness of her belief in the public interest. And one of the cases in the authorities is the recent decision of Mr Justice Stane in Banks and Cadwallader, where she addresses this. And the approach that she takes, which I'd welcome your response to, is that you can test, or should test, the reasonableness of a belief in these circumstances by reference to the what the defendant thought she was saying, unless the and save to the extent that the alternative meaning was obvious, which is why the word obvious seems to be of some interest here. I'm struggling now to find the...
It may be somewhere in the recent paragraph.
I marked it up in another...
It may be paragraph 409.
I don't think it's that.
Or if it's in the...
It's 1, 2, 3 on page 1074 of the Authorities Fund, volume 2.
Yes, it's the reference to Bonnick.
Yes.
Yes. Well, and this of course is dealing with when the journalist is preparing to publish the words complained of. And whether,
yes, of course, it's not, as you point out in your skeleton, it's not directly applicable,
no.
But it's of interest because it's in a related context.
Yes.
And it's about how you assess the reasonableness of a journalistic belief. Let's ignore for this purpose the distinction between the defendant and a journalist.
Yeah.
The test that Mrs. Justice Stane drew from the Authorities was that the meaning that wasn't realised should not be ignored if it's obviously one possible meaning or glaringly obvious. To do so would not be reasonable. Now, if that is a right approach, it's a fairly generous approach to a defendant, perhaps. But if that's an appropriate approach, then the point I was putting to you was that your client would be in some difficulty on the findings of the judge.
Well, if the judge had found that my client should have realised, then that would be a valid point to go into the balance. But the judge hasn't done that. And my client's evidence was that she didn't recognise that ambiguity, and it wasn't challenged.
Yes, but that's again confusing what she actually thought and what she should reasonably have thought.
Well, the judge hasn't made any finding that she should have realised.
Well, the judge did. The judge said it was unreasonable, and that's why you failed on the public interest defence. Rightly or wrongly, the judge said it was unreasonable not to have reflected that ambiguity.
Yes, but what he
And
did...
that, and so a reasonable, prudent, competent person, whatever, it stops it being a reasonable belief.
It's paragraph 124 to
Yeah.
125. But nowhere in these paragraphs does the judge explain why he says it's unreasonable. We say the problem here is the judge made his initial finding about the misrepresentation. And that is simply, as the judge made clear in, I think, paragraph 130, yes, that decision was fundamental in his rejection of each of the defences. Nowhere does he say in 124 or 125 that it was unreasonable because it was obvious and she should have realised it. And of course, that feeds back into the question of, well, is the judge making a finding in 74 that because it was obviously ambiguous,
Well,
every single
sorry,
person...
the finding is one of misrepresentation.
Well, the misrepresentation simply means misstating something. Mr Bennett suggested that misrepresentation cannot be equated with reasonable conduct. That's simply wrong. You can make a negligent misrepresentation, you can make an innocent one. You simply misstate something. And of course, that again has echoes of the judge's reliance on his remarks in Turley, where he referred to the misrepresentation on the part of somebody who hadn't found any supporting facts and stopped investigating. We prefer the formulation of my Lord Justice Warby and Yo, and we say we pass that test. The misrepresentation, it's a loaded word, but it doesn't need to be. All it means is inaccurately represented. And it's possibly less loaded, put in that way. But I understand why Mr Bennett makes the submission he does, but it simply doesn't. The judge's judgment would be... The judge clearly took my client at her word when she said what she believed the only meaning of the tweet to be, of the good advice tweet to be. So the misrepresentation must be the equivalent
How
of...
does that square with what he said in 126? I appreciate we've been over this before, and I apologise for asking the question one last time. But in 126, he says, the contemporaneous tweets of the defendant demonstrate an awareness that she was offering an interpretation of the GOT. Within 30 minutes, the defendant's tweet had converted that into the only interpretation.
Well, if one looks at the paragraph 10, where you see what the tweets the judge is talking about, what you see is the judge has mischaracterised this, because what you've got is the defendant setting out two tweets explaining her thought process as to why the tweet means what it means. This is why it means this.
And the key word that is present in both of those, which is not present in the tweet complained of, is the word implies.
But my lord, that isn't significant, because if she implies that Jeremy Corbyn deserves to be attacked, she stated that Jeremy Corbyn deserves to be attacked. The word implies isn't material. It's implied because it's not explicitly stated, but the statement is still made. But what the judge does in 26 is set up a false dichotomy, because in the two tweets in paragraph 10 of the judgment, my client isn't setting out an interpretation. She's setting out the interpretation which she believes the good advice tweet merits. And then in the tweet complained of, at 9:03, she repeats that in substance. She says, she's tweeted this, don't deal with her. It's dangerous and stupid. There's no change there. It's simply my client repeating her analysis. Or, sorry, it's not repeated. The first two tweets are more elaborate. but there's no change. There's no acknowledgement in the earlier tweets that there's a range of reasonable meanings, which she then excludes all save one. It's simply the same thing, retweeted. Sorry, not retweeted, tweeted again. And Mr Bennett, towards the very end of his submissions, pointed out that this was a serious allegation, tantamount to inciting violence. That was a meaning for which the claimant contended in front of Mr Justice Nicklin on the trial of preliminary issues and was rejected. And in terms of, it says risks inciting, not that she incited. Sorry, the risks are not that she incited, which is the way it was put. And the fact that it's a serious allegation and has to be tempered with the content of paragraphs 155 and 157. The serious allegation came back because of a reaction of which the claimant could hardly be surprised and could hardly complain. And there is still no recognition on the respondent side of all of the circumstances in the case. The focus is always on the unbridgeable gulf. My Lord Justice Arnold sought to draw out from Mr Bennett some recognition of the other circumstances, but there is none. The judge focused inappropriately on the misrepresentation. We say that's far too narrow in the circumstances of this case. All of the factors that are set out in the defence in the paragraph that I provided to your Lordship earlier are relevant and required a proper assessment by the judge when assessing whether or not my client's belief that sending her tweet was in the public interest, assessing whether or not that was reasonable. We say it clearly was. Can I just point out that I don't need to establish that the judge's findings were perverse. I need to establish the threshold that's set out. I think we've put a case in our skeleton, but there's a more up-to-date case in the bundle. It's Sprint Room.
Which divider?
It's in. Sorry, if I can just find it. Sorry, I apologise.
Yeah, well, that's on circumstances which this court will intervene in the finding of fact and
Evaluative assessment.
and
Yes.
evaluative assessments and the limits on that.
Your Lordships are obviously familiar with it, so I'll leave it at that. So Mr Dean's trying to attract my attention one last time. Nope. 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 Mr Dean doesn't need me. Are your Lordships finished with me?
Yes. Thank you all for your assistance. We will consider our judgments and they will be disseminated in the usual way, which is to say they will go out in draft first under an embargo, and I hope everybody in court now realises the importance and seriousness of the embargo. The purpose of that exercise is so that you can correct typos in the draft and obvious errors like transposing names and things of that kind, wrong dates, not to re-argue the case. The other purpose of the exercise is hopefully to enable you to agree a consequential order in the light of what we've decided. If you can't agree a consequential order, then please put in brief written submissions on the points where you are in disagreement. I make no promises as to when judgment will be handed down, but when it is finally handed down publicly, it will be done electronically and there will be no need for attendance.
Court rise.
You're becoming an expert on